Today we're going to be talking about a decision that just came out of a 3-judge panel, the Ninth Circuit Court of Appeals. The case is called USA v. Duarte, and it stands for the proposition that non-violent felons are still entitled to keep and bear arms. Let me start off by saying that Judge B, who wrote the opinion for the 2 justices on the 3-judge panel, both himself, B, and Van Dyke, I think got the ultimate conclusion correct. I'm a little iffy about some of the legal reasoning. Most of it I actually completely agree with, but there is one central component that I do take issue with. Now, having said that, I don't think that it jeopardizes the decision at all, okay? That being said, it does require a little bit of introspection from a philosophical standpoint. The other judge, Judge Miller, interestingly enough, he's a dissenting judge in this opinion. And this also goes to show that just because a particular president might have nominated you to put you on the bench does not necessarily mean that we can predict your judicial outcome. All right, we'll talk about that as well. All right, so the bottom line in Duarte is that the Ninth Circuit, at least a 3-judge panel within the Ninth Circuit, felt that Mr. Duarte, even though he is a felon, is still entitled to keep and bear arms in contradiction to 18 USC 922 G1, which makes it a federal crime for someone who is a felonious status to actually be in possession of that firearm. This 3-judge panel essentially, at least within the context of the Ninth Circuit, invalidated that law as applied to Mr. Duarte. So the case, as I mentioned, is USA v. Duarte, aka Shorty. Apparently, this is his nom de guerre. And Mr. Duarte has somewhat of a colorful past. The fact pattern of the case is kind of unique. Well, maybe not particularly unique, but entertaining to say the least. So Mr. Duarte is accused and convicted of felonious vandalism at one point in the past. This negates his ability to be in possession of a firearm. Apparently, he subsequently picked up a secondary conviction as well. Anyways, on one particular night, Mr. Duarte and his friends are driving in a vehicle. Mr. Duarte's in the back seat. A responding police officer sees the vehicle driving by, notices that the windows are tinted, and decides to initiate a traffic stop. In the process, the driver of the vehicle decides to flee the scene, shall we say, and in the ensuing chase, officers witness Mr. Duarte throw a handgun out of the back window of the vehicle. Subsequently, the occupants of the vehicle are detained, and Mr. Duarte is charged with being, they find the gun, of course, he's charged with being a felon in possession of a firearm. He's convicted at trial, and then he appeals his conviction under a Bruin theory. The 3-judge panel ultimately agrees with his argument. So let's talk about Judge B's analysis of this. Essentially, he says that the state makes the argument that Mr. Duarte is not entitled to be able to keep and bear arms pursuant to 18 USC 922 G1 because he is not part of the people. The people references law-abiding citizens. And since Mr. Duarte, while he is a citizen, is not law-abiding, as evidenced of the fact that he happens to have suffered a felony conviction before in the past. He is now stripped of his Second Amendment rights for the entirety of his life, and 18 U.S.C. 922 G1 is perfectly constitutional. Judge B and the secondary judge who also voted to overturn the conviction, Judge Van Dyke, disagree with the state's position. And in doing so, they go through a Bruin analysis. Now, if those of you watching this video are paying attention to the Supreme Court case that we are likely to get a ruling on here in the next couple of months at least, U.S. v. Rahimi, you might see some degree of a connection. Mr. Rahimi in the Supreme Court case is effectively, was charged with being in possession of a firearm, even though there was a civil restraining order preventing him from being in possession of a firearm. And the Circuit Court of Appeals, when they did their analysis on that one, found that to be unconstitutional. Like Mr. Rahimi, Mr. Duarte, they both sort of fall within this criminal status. And effectively, without going into all the legal reasoning associated with this case, Judge B says, no, you know what, at the time of the ratification, remember Bruin's core test. The first level of analysis is to determine whether or not the individual's Second Amendment rights have in fact been abrogated as a result of this statute. Well, in this particular case, Mr. Duarte is not allowed to possess a firearm, so by definition, his Second Amendment rights have been abrogated. Now the burden shifts to the state, and the state has to show how this law, in this case 18 U.S.C., is consistent with our nation's history, text, and firearms regulatory traditions that existed at the time of the ratification. Now, in this particular context, as in other cases, the state has argued we don't need to get to step two. All right, that in step one, we are able to essentially win our argument. The Second Amendment only applies to the people. And in this case, Mr. Duarte is not part of the people. So this case really focuses in on whether or not the individual that's challenging the law actually falls within the scope of protection of the Second Amendment. Sort of, who are the people? Now, if you were watching the confirmation of Justice Amy Coney Barrett at the Supreme Court, you might remember that there was a case that she was involved in when she was an appellate judge called Cantor v. Ohio. And in that case, she dissented. She felt that 18 U.S.C. 922 G1 was in fact unconstitutional. In that case, Mr. Cantor was convicted years ago of mail fraud. And as a result of that conviction, he was stripped for the entirety of his life of his Second Amendment rights. Well, he sued, claiming this was a violation of the Second Amendment. In that case, the appellate court agreed. However, Justice Barrett, she dissented. She said at the time of the ratification, there were not virtue tests to determine whether or not someone would be stripped of a specifically enumerated right. And in fact, as we go forward, we would look and we would say, is the individual that is being prohibited from bearing arms a dangerous felon? Not a felon in general, but an actual dangerous felon. And one of the reasons for that is that the number of felonies that exist today are far greater than the number of felonies that existed at the time of the ratification. Back then, there were actually very few felonies that actually existed. In reality, if you were guilty of a felony, you probably were going to be put to death. That most felonies were capital crimes. Those that fell below capital offenses, those were usually regulated to misdemeanor status. Now, in our modern society, we've altered that pretty dramatically. There are a number of felonies that exist. And in fact, Judge B actually cites a Florida statute and says, in his opinion, if someone were to engage in a romantic gesture and send up a bunch of heart-shaped mylar balloons in Florida, he would be guilty of committing a felony and thereby stripped for the rest of his life in exercising his Second Amendment rights. This is clearly outside the scope of what our framers had intended. Now, I mentioned at the beginning of this video that I do take issue with a certain philosophical approach that Judge B, and by extension, Judge Van Dyke, used in determining who the Second Amendment actually applies to. In this opinion, both judges focus on who the people are, and they reference numerous times that the people are law-abiding citizens. This in and of itself becomes somewhat of a problematic analysis, because if civil rights only extend to citizens, then that effectively reasons that civil rights are somehow a manifestation of the government. If that is the case, then by definition, rights are transient. They can be taken away based on the political whims of the majority, irrespective of whether the Constitution prohibits that conduct. A right, as I've mentioned before in previous videos, a right needs to be transcendent. First and foremost, a right needs to precede the Constitution. The Constitution doesn't grant rights. The Constitution recognizes rights that pre-existed the Constitution. Well, think about that for a second. If a right pre-existed the Constitution, then by definition, the right pre-exists citizenship. And in fact, the Declaration of Independence specifies this quite clearly. There are certain inalienable rights, rights you cannot relinquish voluntarily: the right to life, the right to liberty, the right to the pursuit of happiness. That is not an exhaustive list. In the Declaration, it says amongst these are life, liberty, and the pursuit of happiness. There may very well be more. Now, the question then becomes, okay, well, where do rights come from? And as I've mentioned before, rights must come from a transcendent source. In the Declaration, they articulate rights as coming from the Creator. Now, from a cosmological sense, most people that engage in sort of a Judeo-Christian mindset would reference that as being God. But it's not entirely a foreclosed statement. You could be an atheist or an agnostic and still recognize that there is in fact a creator. You may not have an anthropomorphic ideal of that creator. That creator could be a scientific sort of a momentary level of existence. The Big Bang Theory, the unmoved mover, if you are a Greek philosophy student. It doesn't have to be some dude sitting on a cloud, but nonetheless, it has to be something that is beyond just people. Because if it's just people, people can change their minds. So rights need to exist beyond simple citizenship. And in fact, when we look at the Constitution in and of itself, and we look at the preamble, we the people, in order to create a more perfect union. Okay, well, let's think about that for a second. We the people, the collective of humanity, in order to form a more perfect union, would suggest that the people exist before the state. Well, you can't be a citizen of a non-existent state. So humanity exists prior to the imposition of an artificial political structure. So rights are not, by definition, dependent on citizenship. Now, in this decision, in the Duarte decision, citizenship plays a major component. Now, ultimately speaking, like I said, they get to the same place that I think a responsible jurist showing deference to Bruen would get to. So in a sense, and certainly in Mr. Duarte's opinion, I'm assuming this was a correct conclusion. But the legal reasoning, like I said, at least in this context, is, in my opinion, somewhat problematic. Now, I'm not just bringing that up to pontificate about some cosmological significance on the origin of rights. Actually, a good chunk of this opinion is based on what type of legal reasoning should be used. And that actually goes to the dissent in this opinion. You see, in the majority opinion, there was a pre-existing case, a case that had been decided prior to Bruen. And the trial court was using that as binding precedent. Now, Bruen didn't expressly overturn this case, and I apologize, but the case, the name of the case, it's difficult to pronounce, so I'm not even going to try bothering with that one. You can, if you read the opinion on this, you can see that case. But in any event, the Judge B says, well, yes, while the holding would not necessarily be expressly overturned by Bruen, the reasoning that was used to achieve that holding was different than the reasoning that Bruen used. And the reasoning is just as important as the holding. Now, interestingly enough, this is not a novel legal theory, but it's one that's seldom used. Most lawyers will look at the holding of a case and say, okay, well, this is binding precedent. The reasoning behind it is obiter dictum. It's interesting, but not terribly relevant. We're looking for the actual holding. In this case, the judge is saying, no, the holding's important, and the holding certainly creates binding precedent, but the reasoning behind the holding is equally essential in determining whether or not that case still is binding precedential value. So if that's the case, then I do take issue with some of the reasoning on this. Now, with all that being said, the dissent, Miller's dissent in this particular case, or Milan, excuse me, dissent in this particular case, he is upset about the fact, not in the Bruen analysis per se, he's upset about the fact that he does not think that the original case should be overturned pursuant exclusively to the reasoning that the Supreme Court used. He is focusing on the procedural aspect of this. So he would have voted to uphold the conviction of Mr. Duarte. Now, what's interesting is that B was appointed to the bench by George Bush, as well as Van Dyke, who joined him in his opinion, was appointed by Donald Trump. So arguably, we've got two conservative jurists on this. The dissent was also appointed by Bush. So you have three Republican presidents that appointed three, arguably, we would naturally assume, conservative jurists. And yet we get pretty divergent opinions on this. We have a majority opinion that's at odds with the dissenting opinion. This just goes to show you that just because a judge has been appointed by a liberal president or a conservative president, that alone does not necessarily aid us in a predictive valuation as to how that judge is ultimately going to rule. Now, I have to tell you, I do suspect that this case will be appealed to an en banc review. The dissenting opinion essentially begs the court to sua sponte, at the very least, bring it up before an en banc review, and it may very well get overturned. But it is another step forward in essentially making a decision as to when someone is ultimately stripped of their Second Amendment rights to bear arms, and at least as it relates to B and Van Dyke, a simple felony conviction for a non-violent felony would not be sufficient. All right, guys, so I'm gonna pause this video for just a moment. USCCA, which sponsors these videos, they're doing a giveaway right now, and it's pretty cool. You're gonna wanna participate. Now, it ends soon. You can read all about it in the description directly below this video, but you're gonna wanna get on it. All right, let's get back to the video. All right, well, guys, if you do have questions and you'd like to email me, by all means do so at steven@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.